Star Athletica was a case that involved a major producer of cheerleading uniforms, varsity brands, and they alleged that Star Athletica, which is kind of a up-and-coming producer of cheerleading uniforms, had infringed some of Varsity's designs.
Star Athletica is a case that involved the application of pictorial, graphic, or sculptural works to a useful article. In general, anything can be protected by copyright. One of the exceptions is that useful articles are not. So what happens to a work that would otherwise be protected by copyright law, a painting or a sculpture, when it's applied to a useful article?
And the heart of that case was whether or not we were looking at conceptually separable and therefore copyrightable designs on useful articles, or whether the designs were integral to the construction of the cheerleader uniforms themselves and could not be separated and thus copyrighted.
The challenge has been that over the decades, the courts have struggled with how to test separability. And there were a great many tests that were being used that had no statutory basis. But it was courts struggling to deal with something that judges are not particularly comfortable dealing with. What is art really? Can I imagine this separated from the useful article?
If the artwork at issue in Star Athletica were on a canvas in a fine art museum or a modern art museum, there's no question that it would be entitled to copyright protection. And so really, what's the difference?
The justices were talking about fashion and function, and that the function of fashion is to make the human body appear more beautiful.
Because this kind of design, it follows the figure of a human body, essentially. And that's the difference between just a design of like stripes and zigzags and chevrons sort of abstractly, and then one that's put on something that looks like a particular piece of apparel that's meant to fit onto a human body in a particular way.
To kind of boil down the Supreme Court's ruling, it's really, can you conceptualize this design as something that's not purely utilitarian, and is it something you'd hang on your wall?
I'm so happy that Justice Thomas wrote a very, very strong opinion saying, guys, go back to the copyright statute. Just read the language of the statute, which does say that anything that is separable can in fact be copyrighted, and a design can be separated.
And the court interpreted this long-standing but very fuzzy question of separability when it comes to the artistic elements versus the useful elements of a design work, and came up with a new standard, or a new test rather, to apply.
What it did do, I think effectively, is clear away all the dross of all those unnecessary tests. And there were many of them. The Supreme Court said, no, stop, don't do any of that work. That's a waste of time, that's a waste of money, and that's not what the statute says. All you need to do is look at the useful article and see if you can identify any pictorial, graphic, or sculptural elements, and can you imagine them separately, and would they be subject to copyright protection if they were separated, either in the shape of the useful article or imagined on a canvas. And if you can, and that isn't a useful article, then it's protected. End of discussion.
Since the 1950s, designs on fabric and on clothing have been protected by copyright. What Star Athletica and Varsity did was essentially maintain that status quo. We can still protect the separable elements of fashion. It's opened the door a tiny bit to ways in which we might think about what elements are separable.
So there was a fair amount of pre-decision anticipatory hysteria around whether the Supreme Court would move the needle in either direction, more protection for fashion, less protection for fashion. And in the end, the court didn't move the needle at all.
Star Athletica was not really a significant case. It got a lot of buzz, and from my perspective, it was kind of a foregone conclusion.
It was very important to the industry not to lose the tiny bit of protection that it does have under U.S. copyright law.
I think if you are an up-and-coming fashion designer, having strong intellectual property protections is important. Fashion and design adds something to our world as a work of beauty, just like any other work of art might.